John Wayne Gacy organized community parades, hosted backyard barbecues, and posed for photographs with the First Lady. He was also burying the corpses of 33 boys and young men in the crawlspace beneath his suburban Chicago home. When authorities uncovered the scale of his crimes, which involved severe sexual torture, bondage, and suffocation, the state of Illinois aggressively pursued a death sentence. He was executed in 1994. Public reactions to serial murderers reveal a profound duality. Society consumes their biographies, dissects their psychology, and turns their crimes into blockbuster entertainment, while simultaneously demanding their immediate extermination. The American criminal justice system mirrors this exact reflex. State legislatures have carefully designed their sentencing structures to expedite the death penalty for offenders who accumulate a high body count. But the Constitution places a strict roadblock in front of reflexive executions, the Eighth Amendment. For decades, the United States Supreme Court has mandated that a state cannot impose a death sentence based solely on the magnitude or the brutality of a crime. The court relies on a legal doctrine known as individualized consideration. Because death is an irreversible and qualitatively distinct punishment, the state is required to look past the crime scene. Juries must be presented with the fullest possible information regarding the unique character, the environmental record, and the specific circumstances of the offender standing trial. Despite this explicit constitutional directive, current state sentencing schemes completely fail this mandate when processing serial killers. To salvage its constitutional integrity, the legal system must radically reclassify serial murder. Instead of treating serial killer status as an aggravating justification for death, the law must recognize the behavior for what the data shows it to be, a mitigating clinical disorder. To see exactly how the law currently bypasses the Constitution, we have to examine the strict procedural architecture of a capital trial. The Supreme Court requires a process called bifurcation, a legal convention that separates proving guilt from deciding the punishment. The guilt phase serves an isolated function. Here, the state is only permitted to present facts proving that the defendant committed the underlying offense. Once guilt is established, the trial shifts to the penalty phase. Before a jury can even consider capital punishment, they must identify specific eligibility aggravating factors tied to the crime. From there, 26 states utilize a framework known as a weighing jurisdiction. The jury receives two opposing forces to evaluate. On one side are aggravating factors, which increase culpability. On the other are mitigating factors, which reduce culpability. The jury can only recommend death if the aggravation outweighs the mitigation. This is where the statutory design breaks down. States like Tennessee, Delaware, and New Jersey explicitly write serial or mass murder directly into their laws. By legally defining a high body count or a pattern of killings as a statutory variable, these states automatically classify the sheer volume of the crime as an aggravating factor. This mathematically double counts the crime. The jury weighs the brutality of the act to establish guilt, and then weighs the exact same brutality again to justify execution, entirely bypassing an evaluation of the individual who committed it. The Supreme Court has historically pushed back against rigid, formulaic sentencing. In landmark cases like Lockett and Eddings, the court struck down laws that limited what juries could consider. The court issued a strict mandate. Juries must be allowed to review an aggregated set of personal mitigating circumstances, and they must be given a mechanism to give that evidence actual legal effect. A system designed to weigh individual culpability collapses when state statutes dictate the extremity of the crime must automatically overshadow the mind of the offender. If courts are required to evaluate the mind of the offender, the analytical lens has to shift from statutory law to clinical psychiatry and neurology. Researchers examining the serial killer population consistently find three specific clinical markers, a combination known as the psychopathological triad. The first component is severe environmental trauma. The vast majority of known serial murderers suffered extreme, often ritualistic, physical or sexual abuse during early childhood. In the 1920s, the notorious child murderer Albert Fish was subjected to daily public flogging while stripped naked in an orphanage. His early normalized exposure to extreme pain mapped directly to his later compulsions. The second component is biological. Neurologists consistently observe physical deficits within the brain structure of multiple homicide offenders. Severe head trauma or perinatal complications permanently damage the prefrontal cortex. the exact region responsible for regulating personality and impulse control. Additionally, chemical blockages in the reticular activating system impair the brain's ability to receive normal environmental stimulation. The threshold for what the individual finds stimulating rises to extreme levels. This is compounded by damage to the amygdala. Impairment here eradicates the brain's ability to process emotional cues, detect fear in others, or experience empathy. The third and final component of the triad is psychiatric paranoia. Mental illness operates in tandem with physical brain damage to trigger aggressive, antisocial behavior. The clinical data synthesizes into a clear biological chain reaction. Environmental abuse generates a deep, perverse, violent urge within the individual, and neurological disease then destroys the physical capacity to check or control that urge. The Supreme Court explicitly defines severe trauma and a lack of impulse control as mitigating factors that reduce culpability. Yet, the criminal justice system takes these exact biological impairments and legally weaponizes them as an aggravating justification for execution. To correct this paradox and comply with Supreme Court mandates, weighing jurisdictions must restructure their legal formulas. First, the serial or mass murder aggravating circumstance must be deleted from state statutes entirely. Second, legislatures must create an explicit statutory mitigating circumstance, formalizing the clinical disorder in the eyes of the court. To prevent this structural shift from serving as a blanket loophole for all violent offenders, it requires strict procedural safeguards. The defense must bear a rigorous burden of proof, establishing the existence of the disorder by clear and convincing evidence. A defense attorney cannot simply cite a difficult childhood. They must present documented medical proof of all three triad components: verified historical abuse, neurological scans demonstrating physical brain impairment, and clinical psychiatric diagnoses of paranoia. This framework forces the jury to look past the visceral horror of the crime scene and evaluate the actual medical capacity of the offender. By formally measuring clinical impairment, this statutory model aligns precisely with the Constitution. It guarantees that the sentencer bases their decision on a reasoned moral response to actual culpability, fulfilling the requirement of individualized consideration. Prosecutors and the public frequently challenge this clinical model by invoking the state's interest in retribution and deterrence. Capital punishment mathematically fails as a deterrent for individuals suffering from brain damage. An offender experiencing total impulse control failure is incapable of conducting a rational cost-benefit analysis before acting. Retribution is often driven by a jury's fear of future dangerousness, the profound anxiety that a serial killer might manipulate the legal system and one day be released back into society. Data shows jurors consistently misapprehend sentencing options, assuming that parole loopholes exist even when they do not. The procedural reality is absolute. A sentence of life without parole is a natural death sentence. The offender dies in prison, and the threat to public safety is completely and permanently neutralized. Structuring serial murder as a mitigating disorder does not forbid a jury from ultimately choosing the death penalty. If the state proves other valid aggravating factors, like pecuniary gain or victim vulnerability, the jury can still rule that death is the appropriate punishment. The model simply ensures the process used to arrive there is logical, constitutional, and clinically informed. A justice system can only claim to be objective if it is willing to weigh the uncomfortable clinical realities of its most despised offenders. True justice requires that the ultimate punishment is a product of constitutional law, not visceral vengeance.